Welcome to S&C's Critical Insights. I am Alex Gross, a partner in the firm's litigation group focusing on technology litigation and a member of our IP and antitrust groups. I'm joined today with my colleague Annie Ostrager, a partner in the firm's litigation group and one of the co-heads of our employment law group, as well as Sabrina Solow, an associate in our litigation group. Today is the second episode in our 5-part series in which we'll discuss a variety of issues relating to trade secret litigation that impacts our clients.
Great to see you both. Let's jump right back in.
Alex, can you talk to us about some recent decisions in the 2nd, 3rd, and 7th circuits and whether you think there's a circuit split?
Absolutely. So I think there is a difference in how certain circuits approach the question of when damages based on a theory of avoided costs are permissible. So the 7th and 3rd circuits take a slightly more permissive approach to this question. The 7th Circuit addressed this issue in 2020 in a case involving Epic Systems and Tata Consultancy Services, or TCS, in which the 7th Circuit affirmed a damages award of $140 million based on a theory of avoided costs. The 2nd Circuit took a slightly different approach recently in a 2023 case, Sintel Sterling versus Trizetto Group. There, while Trizetto originally was the defendant, it countersued Trizetto, alleging trade secret misappropriation. The jury awarded Trizetto $8.5 million to compensate it for past damages in the form of lost profits. In addition, the court issued an injunction prohibiting Sintel from using the at-issue trade secrets. And the dispute between the parties that made it up on appeal was the question of whether Trizetto also was entitled to $285 million based on a theory of avoided R&D costs. The 2nd Circuit concluded that Trizetto suffered no compensable harm beyond lost profits that could support a $285 million unjust enrichment award. Essentially, the court found that Trizetto already had been compensated for past harm through the award of lost profits, and that it also had received a remedy that would address any prospective harm because of the court's injunction.
It therefore found that Trizetto was not entitled to an unjust enrichment award of $285 million based on a theory of avoided costs, in addition to the monetary damages and other remedies it already had been awarded. And the court effectively found that awarding unjust enrichment damages based on avoided costs in this situation would merely result in a windfall to Trizetto because there had been no damage done to the value of the trade secret.
There's no threat of prospective harm to Trizetto, and Trizetto already had been compensated for past harm. Well, this is a narrow difference between the approaches taken by courts in the 7th and 3rd circuits on the one hand and the 2nd Circuit on another. It's an important distinction about when damages based on a theory of avoided costs may be available. And it's an important consideration that parties should think through when deciding where to file trade secret litigation or when a party receives a complaint alleging trade secret misappropriation.
Thank you, Alex.
Given that companies often operate around the world, it's worth touching briefly on the scope of the DTSA. Alex, do you want to take this one?
Sure. So this past summer in Motorola versus Hytera, the 7th Circuit addressed a question of first impression, whether the DTSA rebuts the presumption against extraterritorial application. And the background facts of this case are fairly interesting. Certain Motorola employees in Malaysia were recruited to join Hytera's new office, which also was in Malaysia. The former Motorola employees took tens of thousands of files relating to Motorola's DMR radios to their new employer Hytera in Malaysia to help Hytera enter the professional tier radio market. Hytera then marketed products that incorporated Motorola's stolen trade secrets in the United States. Now, if you recall from our first episode, Annie mentioned that the DTSA was enacted in 2016 by amending certain sections of the Economic Espionage Act, or the EEA. And that's important to this statutory interpretation question that the 7th Circuit recently addressed. The EEA had made theft of trade secrets a federal crime and included a provision stating that it applied to conduct occurring outside the United States, where there was an act in furtherance in the United States. This in furtherance language is located in Section 1837 of Chapter 18 of the United States Code. The DTSA then created a private right of action in the preceding section, Section 1836, but did not change Section 1837, which includes the act in furtherance of language applying the EEA extraterritorially. So the question the Second Circuit had to consider was whether the provision in the Economic Espionage Act applying the crime of trade secret misappropriation extraterritorially also applied when Congress added a new private right of action to the same statute. The Seventh Circuit agreed with the district court that the DTSA rebutted the presumption against extraterritoriality, in part because of Congress's clear intent in amending the U.S. Code to, quote, extend the extraterritorial provisions of Section 1837 to Section 1836, i.e. the provision that creates a private right of action. On substance, the Seventh Circuit agreed with the district court that Hytera's marketing of products incorporating Motorola's trade secrets, including by showing those products at trade shows in the United States, constituted use of Motorola's trade secrets in the United States. The Seventh Circuit also affirmed the district court's holding that Motorola was entitled to relief based on Hytera's worldwide sales of infringing products, quote, regardless of where in the world the remainder of Hytera's illegal conduct occurred.
Annie, anything to add to this?
I'll just note that Hytera filed a petition for cert in the Supreme Court in January, arguing that the Seventh Circuit's decision violated the presumption against extraterritoriality. So we'll be watching this case closely, and depending on how it comes out, it may be a good one for the civil procedure treatise that you and I worked on together, Sabrina.
Right. Thanks, Annie. Let's round out this episode on trade secrets with a discussion of mandatory disclosure regimes.
This is an important topic in trade secret cases. The general dynamic is that plaintiffs want to avoid disclosure of their trade secrets until as late as possible in the litigation, while defendants will push for earlier disclosure to limit the scope of discovery to the specific trade secrets at issue, and in order to help develop their defenses to claims based on specific trade secrets at issue. In certain jurisdictions, plaintiffs have a statutory pre- or early discovery obligation to disclose trade secrets with particularity. For example, Massachusetts and California have both enacted statutes which require pre-discovery trade secrets identification. New York, the only state that still applies common law for trade secret misappropriation claims, as Alex talked about in our earlier episode, does not have a law that requires pre-discovery disclosure, but courts in New York have required specific identification of trade secrets early in the case, well before the close of fact discovery, and as explained in the Federal Judicial Center's Trade Secret Case Management Judicial Guide, the predominant pattern and growing consensus is that courts will require early identification of trade secrets in the discovery process because this helps reduce the risk that alleged trade secrets become a moving target and helps to appropriately define the contours of discovery.
Thank you for that interesting conversation on a number of issues percolating through the courts. Thank you for listening to S&C Critical Insights. Please stay tuned for our next episode in this series. And for more information about our practice, please visit us on the web at www.solcrom.com.